Okay, welcome everyone. This is our final weekly speaker series of the semester as we head into exam period and winter break. We're going to take a pause, but we've saved one of our best speakers and best friends for today's session. I want to introduce my friend, Professor Takashi Maruta. He's not only my friend, but he's been a friend of NYU and the U.S. Asia Law Institute. He was a visiting scholar here for a year, and we couldn't let him leave, so we asked him to come back again. And he and I co-taught a class on comparative criminal law, Japan and China. Professor Maruta is Professor Emeritus at Kwansei Gakuin University Law School. He's also a practicing criminal defense attorney and an expert on all things related to the Japanese criminal justice system, but especially the lay juror system in Japan. And of course, the death penalty, which is the topic for today's talk. So I won't delay any longer. You can find his bio on our website. And Professor Maruta, please take it away.
Sure. Thank you for inviting me. I'm very happy to, appear. Used to be, I think, a Jerry's class. I mean, Jerry's Wednesday, and I go there and joined because I can eat tasty Chinese food. So, anyway, let me start about death penalty outline, and I'd like to show you. Why not start? I would like to focus on the relation with Saibain, which is the lay participation system in Japan, introduced 10 years ago. And that's a kind of a quasi-jury system. 3 professional judges and 6 lay assessors jointly discuss the case and decide the facts, and also they decide sentencing. So I would like to show you some relation with Saibain trial and death penalty, which is a very interesting issue because it used to be for 60 years after World War II, Japanese criminal trials were handled by 3 professional judges. So next slide. I would like to move on. This is the number. So Japan is still active country to execute the death law, and this is the number shows some years, say 2008, in a year 15 were executed, and look at the 2011. 0, because the number is really up to the Minister of Justice, who signs of the order of the execution. So the number is, varies, but it's really up to the Minister of Justice. So sometimes many were hung, and sometimes less than 3. But still, you should remember or keep in mind, Japan is always best 10. I mean, not best, worst 10 on the execution number. So Japan comes after United States. And 2018, Japan executed 15 death law, followed after United States. So you can see from this international data, many countries which are not so economically developed, and China, Japan, and the United States is the kind of leading country in the economic sense. Okay, so how Japan frequently excused people, I mean, executed the people, hanged the people, you can compare with American state which has the death penalty. Of course, Texas is famous for the frequent execution of death law. And Japan comes next after Texas. And even Japan is double with Georgia, Oklahoma, or other, United States, which has a death penalty. So you can understand Japan has frequently executed the people. And now focus on the Taiwan. And Taiwan, as I said, consists 3 professional judges and 6 lay assessors. They are selected from some candidate, some group randomly selected from the voting lists and interviewed and randomly selected. So it's very tricky. You should hear very carefully how to vote. How to decide death penalty among 3 judges and 6 laypersons. It's first of all, it's not unanimous. In the United States, the death penalty states sometimes ask a jury to decide that death penalty. And almost all states which has death penalty states ask the jury verdict must be the unanimous, except Alabama, which is the 10-2. But Japan is just majority. So among 9 people, 5 agrees. That is their decision. But I put the special because it's not simple majority. The majority must include it's the law order that at least one judge. So 5 lay people cannot decide by themselves. It must include one judge. That's a special majority vote. And how to decide the sentence? If you vote one time, writing on the paper, death penalty or life imprisonment or imprisonment for 30 years, and they vote. And then if you have more than 5 for the death penalty, it decides, it's the end. If in the 5, 5 majorities include one judge. But if it's divided, it's divided small numbers. So the law says the hardest, the severest sentence will be added next to severe sentence. So death penalty, 3 people, and then life imprisonment, 3 people. So added 6, that makes 6 persons, that is the majority. And if it includes one judge, the sentence will be life imprisonment. So I'd like to show the this illustration. Red one is lay citizen, and the blue one is judge. So if in one vote, the first vote, they opened the voting, and then 4 lay citizens voted for death penalty, and 1 judge voted for death penalty. That makes 5, including judge. So it's automatically determined death penalty. Even though life imprisonment people are discussing this, so they can just ignore that. But the second case is 3 persons, including 1 judge, voted for death penalty. And 3 people, 2 lay persons, 1 judge voted for life imprisonment, and the others, 2 citizens and 1 judge voted 30 years. So as I said, the hardest one will be added next hardest one. That means so it makes 4 lay citizens and 2 professional judges. That makes majority. So therefore, the sentence will be life imprisonment. In this way, they decide the death penalty. And there's some argument and criticism why it is not um, unanimous. And I always say that it must be unanimous, even they vote whether guilty or not guilty is um, special majority voting. But sentencing, especially death sentence, should be unanimous. But they don't want to change this rule. So last year, January, you can see the percentage of their裁判員 sentence. So mostly more than 3/4. I mean, so 80% voted for limited term imprisonment, 3 years imprisonment, 4 years, and that kind of thing. And suspension of the sentence is 70%, and life imprisonment is 1.9%. And capital, that means death penalty is 0.3%. So you have some question about how about comparing to the judges. So that's the next one. This is very interesting data. I just made it. So I would like to show very interesting stuff. In the vertical line, the numbers of victims, 1, 2, more than 3. Those are, the person who were killed. So the victim's number is 1. And I go to the horizontal way. And first column is 3 judges, professional judges system. And since Taiwan system introduced 2009 May, so 2009, by the end of April, they have still the professional or judges system. And from May 25, they started Taiwan trials. So it is very interesting comparison. 1980 to 2009, I would go explain the horizontal way. Because the killed person, numbers of the victims 1. Prosecution request cases is 100. So the victim is 1, but still prosecutor requested death penalty. Then 3 judges decided death sentence 32. So the percentage is 32%. Okay, and next, Taiwan. I go on to the horizontal way in the top column. Prosecution requested in one person victims, 8 cases they requested death sentence. And Taiwan decided 4. So that means 50% more than professional judges. And when it goes to the 2 victims, the defendant killed 2 persons. 164 requested death penalty, and 96 decided as a death penalty, 59%. Taiwan trial, 32 requested, 19. And this is very interesting coincidence, 59%. But more than 3 victims, including 3 persons, prosecution requested 82, and 65 said death sentence. The percentage is 79. But look at Taiwan trial, 13 cases. In 13 cases, their victim was more than 3. Prosecutor, requested the court death penalty, and all 13 cases are decided by Taiwan. So that's 100%. So look at the last number is total death inclination percentage, death sentence inclination percentage. Taiwan, 3 judges system, 56%, but Taiwan system is more than 56. They are more prone to decide death penalty. Well, based on these, data, I can say that. So next, this is a very much complicated, but it is very interesting graph. You can just focus on blue line, blue just the chart, and then the red one. Blue line, it shows still, there's a cases which is just decided by 3 judges, and other cases decided with Taiwan trial. Taiwan trials usually handle very severe felony cases, and the percentage very low. I mean, less than 10%. So 90% it's handled still professional judges. The, the they sometimes appeals about the sentencing unfairness or unequal lax balances of the crime, or whatever reason they can appeal the decision of the first instance to the higher court. And usually professional judges case or professional judge case, their reversal rate is 11.2. I mean, not more than 12%. But Taiwan trials after 2013 to 2014, it increases. That red line shows the percentage overturned, reversed at the higher court on the sentencing. So Taiwan sentencing, not only death penalty, but also other severe, severer sentences overturned by a higher court. This graph is also very interesting and very suggestive. So you can ignore the right side Chinese characters one, Japanese characters one, but I would like to show this because percentage, I mean, used to be now 2020, and from the beginning to 2020, we have 7 cases, which were 7 cases that decided death penalty, but overturned, reversed by the higher court. 5 cases. Now, so 5 cases are finally approved, upheld by Supreme Court. So Taiwan decided death penalty, but higher court denied that, changed to life imprisonment, and Supreme Court accepted that. So how about left 2, reminded 2 cases that is now discussing on Supreme Court, maybe accepted. So I would say by the next year, all 7 cases which the Taiwan decided death penalty will be overturned by the higher court. So the you can see the number of victims 1, 1, 3, 2, 1. So some cases are 4 victims. I said that in the 7 cases, and that is still, Taiwan decided death penalty, but higher court said the case, the defendant is, they have some insanity or lack of, common sense. So not common sense, like some ordinary sense. So mental handicap they found, and then change the sentence. So the inclination of Taiwan renders sometimes very harsher cases, decisions and sentencing, but they will be carefully checked by, overturned by higher court. And what I want, so maybe you think that what's the reason? Well, the very interesting stuff is when the introduction of Taiwan system 2009, the government introduced victim participation system, which is very interesting or weird case. We have the system because a victim can attend, not to witness, but as a party. And they are sitting with prosecutor's seat. And they can ask questions to the witness and also defendant. And also, this is important, second, they can state their opinion on the case, on the fact, of the case. And also they can recommend or they can require, request the court, the sentence, usually very severe sentence. Please, um, decide the sentence or something. So usually they cried, very emotional. So this is not empirically or psychologically decided how much their appearance or their appeal to ask a severe sentence influence over the cyber decision is not clear, but uh, somehow, this kind of thing is, my guess, influence of the harsher sentence, I think, by the cyber. So we should go back more um, theoretical point. Since there's no guideline for deciding or for deciding death sentence, but Supreme Court case 1990, which is, you should remember the Nagayama case, who was 90 years old, and he entered into American military base, Misawa city, Misawa base, and stole the handgun and killed two persons. I'm sorry. Oops. I'm sorry. It's, sorry. And he killed four persons. But at that time he was 19 years old. And he has a little bit, the mentally handicapped, and he was sentenced to death by Tokyo District Court in 1979. But the Tokyo High Court said since he was 19 years old and so a minor, and also he had lacked some sense of the balance of other things. And then, so the Tokyo High Court said it must be. Why it goes here, I don't know. Okay, anyway, so and then Nagayama case, the Supreme Court provided 9 elements to consider the death penalty: nature of the homicide in question, motivation behind it, mode of crime, especially the remorselessness and cruelty of the means of crime, seriousness of the consequences, and especially number of the victims, feeling of the bereaved family toward the culprit, a magnitude of social impacts of the case, age of the defendant, previous convictions of the offender, and circumstance after commitment of the crime. So these 9 elements, considering these elements, and also based on above 9 elements, if death penalty is still unavoidable or not. So the court stance is very, careful to sentence the death penalty. So it is 1990s a kind of death penalty sentencing guideline or criteria. But these days, after cyber era, they put more on other aspects or among 9 elements, they just picked up very much careful point. That is premeditation of the crime and cruelty of the guilty act, and also aggrieved parties' feelings. Okay, this is very important because premeditation of the crime can be proved, legally evaluated by showing evidences and other things. But cruelty of the guilty, cruelty of the crime. Someone said, he was stabbed by sharp knife. That's cruel. And but other person said he was stabbed 10 times by say, fruit knife. So it is very, kind of not stable. What is the cruelty of the crime? Crime itself is very cruel. I mean, so it's very difficult. And sometimes impressions or the bloody pictures influence over there. I mean the decision. And also, much more difficult is aggrieved parties' feelings. Well, of course, those who lost, their important person and partners, they cried and they are very much upset. And so I can imagine, they must be enraged at their action. So they request harsher sentence um, anytime like that. But if it is the element, it will be more, I mean, that's criminal sentencing or criminal penalty will be very retributive. I mean, kind of revenge of the crime. So I think these two elements um, emphasized, but this is Taiwan's era's kind of futures of the sentencing stage. And still, Japanese people supports death penalty more than 80% every year. These popular, poll, I mean, survey of the popular opinion about the death penalty system is carried out by the cabinet, I mean, the government. So the question is must be a little bit tricky, but still, I don't see any survey other than this shows more than 50% is against death penalty. Death penalty, I mean, supporters are always 70 to 80%, and those who want to abolish it is less than 20%. It's every time. So Japanese people really supports death penalty. So point is why? Well, maybe they don't know the reality of the death sentence, and also they still believe in the effect of existing death penalty is a deterrence of the harsher crime. Or maybe people think, as I showed you, aggrieved parties feeling life should be, compensated for those who killed some persons. And also the death, I mean, Japanese execution of the death penalty is carried by hanging. And hanging is sometimes, not used because of the severe or cruel. So so it is going to be, I mean, extinguished. I mean, they are going to go. I mean, there are very few countries which use the death, I mean, hanging. And so there's argument among the legal scholars and lawyers. Hang is a cruel punishment, which is prohibited by the Constitution, Article 36 of Japanese Constitution. So that the issue is now how Japanese people can change their attitude. I mean, the country, I mean, worldwide trend is abolishing the death penalty, but Japanese people are trying to keep it. Why so? And how, it should be changed. That's one point. And also, hang must be changed. Injunction, no, injection. Um, so to avoid some pain and suffering. So that those they argued in now. Okay, that's it. That is my talk. So please, if you have a question, I'm happy to respond to you.
Okay. Professor Maruta, thank you for giving us that introduction. I do have a couple of questions. I want to start out with
Sure.
a comparison with another East Asian country in China.
Mm-hmm.
In China recently, in the last 5 or 10 years, one issue that's gotten a lot of attention in death penalty cases is courts consider whether the victim's family has forgiven the defendant. And I guess that's similar to the factor you're talking about in terms of the feelings of the aggrieved party. But in China, the position of the victim's family is often influenced by whether or not the defendant pays compensation to the victim's family. And there have been some reported cases where the victim's family has actually used this issue of forgiveness to extract or demand an amount of compensation from the defendant's family. So I'm wondering if in Japan, if this issue of compensation by the defendant to the victim's family exists at all. Is that something that even occurs? Can the defendant's family even pay compensation to the victim's family? And if they do so, is that a factor in deciding whether or not to impose the death penalty?
Shall I answer that first? Okay, I mean, it's a mixture, but I would say for the death penalty, there's no room for compensation or paying some money at all. Therefore, if you pay $1 million, there's no consideration about the suspension of death penalty. But lesser offense cases such as hitting people or maybe stealing someone larceny or other things, sometimes judge asks whether a defendant or defense lawyer are compensated, paid some money and agreed among parties. So it sometimes makes the suspension of the indictment and sometimes get to the lenient sentences. But it's really I think it's demeanor cases, not felony cases.
So it's just not an issue in serious cases, including death penalty cases.
Exactly.
So another question of comparison in the United States, in the states where they still have the death penalty, when during the selection of jurors, the prosecutors or the court are permitted to ask the jurors whether they are morally opposed to the death penalty in all cases. And if a juror says, well, regardless of the evidence, I don't think the death penalty can be justified, that person won't be allowed to serve on the jury. So as a result, the people who serve on the jury are all people who will say that they believe the death penalty is appropriate, at least in some cases. And that's a point of criticism by some of the death penalty in the United States. Now that Japan has the lay jury system, I wonder in the selection of lay people to serve on the jury, if they're asked before they serve whether or not they have any moral objections to the death penalty. You know, in other words, is there a similar qualification that only people who believe the death penalty can be appropriate can serve on as lay jurors in a capital case?
That's interesting. In Japan, usually you should understand the sentencing request is almost the final stage of trial. So they just show the evidences and then argue the evidences and concluding remarks. And then final statement, prosecutors usually request the court which sentence should be rendered. So at the first stage, nobody can tell whether, because, you know, the defense will raise some self-defense or insanity or some consent, other things. So we cannot tell what kind of sentence will be requested. Of course, we can guess. So first thing you should consider is at the Japanese trials, sentence will not revealed yet while trial is going on, and later they just ask the court. So at the裁判員 selection stage, usually it is not permitted to ask whether you are prone to death penalty or not, because it is not decided, and judge will stop that kind of question. And usually they don't do that, actually. So we don't have such problem in selecting Taiwan lay jurors, the
Hey,
judges.
so we're starting to get some questions in the Q&A, and I just want to encourage everyone listening to post your questions in the Q&A section, and we will read them as we go along. So one of the questions is about the process you described for voting between the lay jury and the judge.
Mm-hmm.
I want to ask, one of the questions is why is it so complicated to have this complicated voting system? Why not just make the requirement unanimous? As a related question, I want to ask whether or not the voting is transparent, in the sense that does the defendant know how many people voted in favor of the death penalty and how many people voted against the death penalty?
Oh,
Not necessarily the identity of those people, but at least was it a 5-4 vote, or a 7-2 vote, or a 9-0 vote? Is that information available to the defendant and the public? And then the question, again, why not just make it unanimous?
I would like to answer the last one. In the law, Taiwan law prohibits the discuss about the contents and how much they vote each other after the trial. The law says Taiwan cannot tell other people or reveal. I should say it is considered. It is a gag order. And then if you, you know, tell the contents of what kind of argument is going on and how much, the percentage of the voting and whether it is unanimous or not. If they just, leak that facts, it will be criminally punished, 6 months in jail or $5,000, that kind of thing. So there's no case yet in Japan about the, so I should say the contents of the argument and how much they vote each other is sealed and kept it as secret. So we cannot know. That's one point. The second one is why unanimous, not unanimous? Well, I'm attended the process of making this system, and I argued that unanimous. I'm a very strong, opinion leader about unanimous things. But government said these cases are very severe cases. Serious cases, and takes a longer time to try out. 2 months and 3 months or something. Then, if the voting is unanimous, if they split or hung jury, hung Taiwan, they have to try it again, and it's a time-consuming and waste of the cost. So government said not unanimous, and because in district court or higher court, 3 judges decide the case, but their voting is majority, not unanimous. That's the kind of model to allow special majority voting.
So very interesting. I am wondering on the question of the vote. You could have a system where the vote is revealed, but the discussions are not. We also have a system in our jury system. Jury deliberations are secret and cannot be discussed, but the vote is actually done publicly. Would the appellate court be made aware of what the vote was? So say at the trial court, maybe the vote was 5-4 and the case was appealed. Would the appellate court be aware that the vote was 5-4, or are they not allowed to know?
I would say there's no court record. Well, that all documents are used in the district court. will be, hand over to the higher court, and the higher court can see all the documents, used in the court. But there's no, I think, no information how much they vote each other. So if the higher court judge asks secretly to the trial judge whether how much, but I don't know what happened. Well, they secretly do that, but I'm not sure. So Japanese judges are so serious and majime. I think they won't do that. So since the law prohibits to reveal the voting results, I'd say even higher court does not want to know. So I'd say there's no record, or even secretly they cannot know.
So I'm going to try to experiment, and I need Alexis's help here. We have a relatively select and small group today, so I wonder if we could turn on the microphones and possibly cameras of people who've asked the question, so they can ask them directly instead of having me rephrase or restate the question. So Alexis, can we start with Bruce Aronson and ask Bruce to state his question?
I unmuted. Okay. So my question was, you made some very interesting comparisons with the US, and we also mentioned China. But I suppose that the countries with historically the most similar systems with Japan are Taiwan and South Korea. And I noticed on one of your early slides that the US had 25 death penalty cases and Japan 15, was it 2018? And Taiwan had 1, and Korea wasn't mentioned. So to the extent that you're aware of it, I was wondering about the situation of death penalty in Taiwan and South Korea as compared to Japan.
Well, I would like to mention that in South Korea, they suspend, they just decide the death sentence, but they usually suspend. So there's no execution happens for, I think, back to 15 years. They never hang or execute any death row at all. So that's a totally different from Japanese and Taiwanese and Chinese situation. So Taiwan is, Korea is different from other Asian countries. And Taiwan is very much similar like Japan. And in Asia, most frequently execution, it happened is Singapore. They also frequently executed. So it's really different, but I would like to pay attention more about Korea's station. And also in China, I'd like to ask Ira, sometimes you mentioned about the compensation will work for the suspension of the death sentence. But sometimes as a system, the judgment is death penalty. But because of some reason, they can suspend of the execution. And then sometimes they were not enforced. They were not executed. So that's much better system. Although China is the #1 country to execute death law, more than 1,000 a year, but still they have that kind of system. So I'm now saying and discussing with the fellow lawyers and professors, why, okay, death sentence, okay, because, for the bereaved family members of the victim, but why not suspend? That means it makes life imprisonment, right? So that's another way to change or to change the system from death penalty or non-death penalty country. I'm sorry, Bruce, I went too far, but
No,
this is my answer.
No, the comparison is interesting, and
Yeah.
we know in Taiwan there's an active movement to abolish the death penalty. But to answer your question, in China, when the death penalty is imposed, sometimes it's the sentence is that it should be carried out immediately.
Mhm.
And sometimes the sentence is a death sentence with a 2-year reprieve, meaning that the death sentence won't be carried out for at least 2 years. And if
Mhm.
during that time the defendant exhibits good behavior, then the death sentence will be converted to life imprisonment. And the defendant may even have an opportunity to apply to the court to have their sentence reduced. But the process is not terribly transparent. And as you may know, the number of death sentences in China is still considered a state secret. We have a few questions in the queue about public opinion. So I wonder, one is from Frank Upham, and one is from Catherine. So I wonder if we can turn on their cameras or speakers and ask them to ask their questions. So Frank, do you want to start?
Yes. Thank you, Takashi, for staying up late. Or maybe you always stay up this late. But anyway, thank you. Only 20% of people are against the death penalty in principle in Japan. First, this is a question for Ira, but you probably also know the answer. What is the percentage in the United States that is against the death penalty? And then second, assuming that the 20% for abolition is low, what does that have to do with religion? Are there any religious movements against the death penalty in Japan? Are they powerful? So that's my question. I also have lots of other questions.
And before you answer that, Professor Maruta, Catherine, do you want to ask your question, which I think is related?
Sure. Yeah, it is. There's some overlap with what Frank was asking. I'm wondering whether the groups that, I assume there are groups that are advocating to end the death penalty, and I wonder if they are just very marginal voices in society, or if they in fact might be loud voices that just happen to be out of step with the rest of society. So in other words, if you're going about your ordinary life in Japan, would you be aware of there being advocacy against the death penalty? Is it something that ordinary people would hear about, or is this whole debate about the death penalty something that only happens inside academies of law, or in very small circles among perhaps elites?
Maybe you. As an addendum to that question, as I mentioned, Taiwan has an NGO that's dedicated to lobbying for the abolition of the death penalty, and I wonder if Japan has a similar organization.
Well, I mean, so related to the, I'll answer to the Frank's question later, but to the Catherine's questions. Japan Bar Association last year, they just cited some decision and declarement that to work for the abolishment of the death penalty in Japan. But still, it is not so popular. That means still in the people's mind, death penalty is necessary. So the reason is why. But I would mention that there are two groups. One group who is very active in abolishing death penalty is those who are involved in, the wrongful conviction cases. Defense lawyers and activists about that, and scholars who backed up that movement and the actions. They just hard enough to work for the government to limit of the death penalty or abolish the death penalty. That's the one group. And the other group is, as Frank mentioned, that some group who is more religiously involve the people, which is not Buddhist, which is not Christians, but some people who are more pay attention of the life of the people. They just say the life is important. And interesting thing is those group involves some constitutional professors and scholars because Japanese constitution mentions life must be guaranteed. I mean, the right of the liberty and life, maintain life is the government cannot take that kind of thing. So these two groups, but still, I would say a very small voice and cannot get majority. And then move on to the second question Frank raised, 20%. And I don't know US. I think I'm sure that's more than 20%, almost 40 or 50, 60% in the US. They support abolishment of death penalty. So it's more than Japan. But my concern is why Japan is so low is, well, I think they have some feeling, as I mentioned to you, they more pay attention of the feeling of the victims or victims' family. They just they have a sympathy to those people, and then those people said should be the defendant should be the death penalty. They are not argue that is wrong argument or wrong request. They just follow that kind of request. Usually, even in Diet Congress, they argue at the legal, system committee. And usually, majority people, elderly people said, when your daughter was killed, do you think still this penalty is not necessary? That kind of argument is going on, and it is supported. And second one is, it is wrong, but still people believe in, because of the death penalty, the severe or harsh, cruel punishment is deterred, stopped effectively. So those two are very much prevailing. And so the point is, if Japan introduced life imprisonment without no parole, maybe people are going to move that direction. But the government will not say whether death penalty or not death penalty. So the question is like that. So people just vote for the death penalty. 20% becomes maybe 24 or 30%, but not more than 50%, I think. I don't know the
So-
US percentage.
Yeah, so Frank, I know you have some more questions, so why don't you stay on? But on this question of public opinion, I just checked, and I think in the United States, it's roughly 50-50 with a
Really?
slight majority against the death penalty. But I think a lot of these surveys depend on how the question is asked.
Mm-hmm.
So if the question is, do you support the death penalty, or are you against the death penalty, or do you support the death penalty or life imprisonment for serious crimes, you might get different answers. But I do want to point out, I meant to mention this at the outset, during this lame duck period for the current administration, one of the most, I think, in my opinion, unseemly actions taken by the current administration is to try to execute as many people as possible before January 20th, since the president-elect has made clear that he opposes the death penalty. In a country where, again, maybe it's 50-50 in favor or against the death penalty, and many states don't have the death penalty, the idea that there is this rush to execution before people on death row might get a reprieve is quite striking to me. So we have a lot of good questions in the queue. Frank, do you want to follow up with your other questions?
Yes, you mentioned the Nagayama criteria.
Yes.
And two of them, or three of them, I guess, clearly indicate a role for emotion. One is cruelty, the victim's participation, the aggrieved party's role. That brings emotion into the trial.
Mhm.
And I think there's a reaction against that idea among American lawyers, at least that's my sense. But I wonder whether you think emotion has a role or should have a role, or should it only be, I think you called in Japanese, the Japanese judges, majime. So in other words, very serious, very bureaucratic in the best sense of that word. I think bureaucrats are extremely important. In the United States, we have emotion too, but it's in the election of judges. So most criminal cases, of course, are done by state judges who are elected, and their election campaigns are very emotional. They're almost always, not always, but almost always in favor of harsh penalties for criminals. So I wonder if you just talk about the role of emotion, and that maybe emotion should be brought into Japanese trials because the judges are so serious. I don't really believe this, but the judges are so serious that they don't have enough emotion.
Well, that's very interesting question. And I think Japanese judges try to get rid of emotional aspect as much as possible. And because two reasons. One is legal education. Well, in Japan, when we think a legal argument or legal decisions, we should find out some element facts, not emotional things. So this judgment, I mean the past judgment or precedents, are based on legal reasoning, logics, and this. I mean the smart kids, I mean, smart students of the law schools and those who will be judge, is very much more obedient on that theory or logic or argument, not emotionally. So well, I don't know. The defense lawyers are more emotional somehow, and myself is too. I appeal the emotional aspects of the defendant in the court, but judges never hear. I mean, never listen to that kind of argument. It's not related. It's not a good argument, and that lawyer just emphasize over the emotional aspect. He is no good. That the stance of professional judges. And in Japan, if the judge is like that, more and more neutral, like machine-like, like IA-like people, uh, I think they are regarded as a smart judges, and it is kind of model to exclude any emotional aspects. Of course, in court, I myself and other defense lawyers usually appeal background of the defendant and why this kind of thing she or he did. But they don't consider that important. Maybe influence over the sentencing, ちょっとだけ, but I think it's not fundamentally important elements. So, as I said, legal education, and to be a good, smart judge, you have to exclude any emotional aspects. So,裁判 trials, they introduce victim participation, and it is kind of very much emotional things. How much they cried, how much they spent sleepless nights, that kind of thing. It's not legal argument. It's a sense of human beings. So, as you mentioned, Nagayama Criteria also has emotional aspect. But if you read the case carefully, the Supreme Court said these 9 elements equally balanced, checked, and then also whether you should consider whether it is unavoidable. I mean, this penalty is unavoidable or not. you should take care of that aspect very much seriously, the Supreme Court said. But nowadays, if the way of killing or way of the murder is very much bloody and some brutal things, you cannot escape from the death penalty because they emphasize that aspect. And also the request of the bereaved family, the victim's family members, taken very much seriously about the considering of the sentencing. I'm not sure I'm answering you nicely.
Well, I mean, it's a great question. I'm not sure there is a one answer to it. I want to turn to a related question, just the issue of support for the death penalty or opposition for the death penalty can be very emotional. And, in some states in the United States, there are many stories about the lack of effective assistance of counsel, especially in capital cases. But in some states that have tried to preserve or revive the death penalty, they've tried to balance the public support for the death penalty with public support to reserve or limit the death penalty for the most serious cases, and also to make sure that the defendant is in fact guilty. And so as a result, as part of the death penalty scheme, they've created special public defender offices to represent defendants accused of capital crimes. I can think of two examples. New York is one, and I think North Carolina was another one. Might be mistaken about the state. But what happened is, in the capital defender case offices, they were given tremendous resources because the notion was, in a capital case, there should be really no limit to what the defense can do. They should be able to hire investigators, hire experts, because we want to make sure we're not making a mistake. Because if there's no way to correct the mistake if someone is executed. And in both of those states, the expense for the capital defender office became so great. Just for one case, the budget would be millions of dollars. And that eventually both offices were closed and the death penalty was abolished, either in practice or legally. So I wonder in Japan if there's 80% support for the death penalty, I wonder if there's also support for giving defendants in capital cases the resources necessary to defend themselves, and also to make sure that the legal system won't make a mistake and order the execution of someone who might be innocent.
Mm-hmm. That's a very interesting question and a very serious question. Well, some cases that's very sensational, say from the first trial or even the investigation stage, the suspect or defendant, mentioned he or she was not guilty and I didn't do it. So it is get the death penalty in the district court and second case. Those cases which have some argument. And so we should, I think in Japan, the case must be, categorized as two groups. One group is the defendant says, what I did was very wrong. I accept any sentence or any penalty, death penalty, fine, because I did very bad things. Those cases, maybe 80 to 85%. So what I say, 15% says, I did not do it, or what I did was some reason, and then so the death penalty is a severe or harder case, so must be decreased to the life imprisonment or something. So only 15%, but usually the media will pick up that 15% cases. Therefore, for that case, they have some group stood up and then try to fundraising and also support particular defendant to save from death penalty, death law or escape from the death penalty conclusion or finalize the death penalty. So that's a movement is really focused on those who are, fighting against the criminal system and also the judgment itself. So I think what 85% should say, very calm, they are just accepted, and sometimes defendant did not appeal to the higher court, although defense lawyer recommend that person to appeal, but they refuse, and I should accept death penalty. Those cases 80 to 85% in Japan still. So I don't know Japanese the culture of harakiri or other things, but they accept the crime. I mean the punishment. So it should be they should accept. But 15% is still again. You mentioned this kind of public support group. We don't have that one, but usually they have some group. Organize some actions and groups. They just support from the beginning to the end. They do that.
So we have a couple of questions in the queue about mitigating factors, and the Nagayama factor. So one question comes from Yincher. So I'm gonna hope we can turn on her camera, her microphone. And the other question comes from Robert Singalis. I hope I'm pronouncing that correctly. So perhaps we can ask them to ask their questions directly. Yincher, do you want to start?
Well, this is Robert.
Okay, Robert.
Very, very brief question. I was curious if there are folks that are excluded from the death penalty. So in the United States, intellectually disabled people are immune from the death penalty. Juveniles are immune from the death penalty. I was wondering if there are outright exclusions in your system, in Japan's system.
Yes. Yes, I'd like to answer that. Juvenile from less than 17 years old, and I should say 18 years old. That means 17 years old of 11 months or 11 months and 29 days. They are legally prohibited to get death sentence. That means they will be the life imprisonment. So the issue is from 18 years old and 1 month or 1 day until the 19 years old and I said almost 20 years. So those people is a kind of borderline. And before Nagayama, in Japanese case, nobody below 20 was not get any death sentence. So Nagayama is the big step to give the death sentence to the minor 9 years old. And after that, it is the beginning. And then it goes on and goes on. And now Taiwan trials gave the death sentence 18 years old and 1 month juvenile. Not juvenile, that's a minor get the sentence. So I'd say less than 80 years old will be legally prohibited to give this death sentence. And second, mentally handicapped people, if the defense is successful and get some proof in the court that the defendant cannot understand or something, mentally handicapped, and so of course we ask the expert witness to show some medical opinion, and the court really becomes careful about that dealing with those defendants. And usually, as I mentioned in my slide, the other case who killed 4 people, was not get death sentence. And in the higher court, this death sentence in Taiwan trial, but it was overturned and to be the life imprisonment. And because court found that he has some mentally difficulty to understand. It's not executed, but they try to avoid the sentence to those who cannot understand completely. And we have two females, women inmates in Japan who were sentenced to death, but they are not executed yet. So to the robot's question, I think legally prohibited 18 years, less than 18 years old, and between 18 years old to 20, it's really up to the cruelty of the crime, and the bereaved families' feeling are considered seriously about whether they decide death sentence or not.
Yeah, I just think, Robert's on referring to a case in the Supreme Court where it's uncontested that the defendant is mentally disabled. Either they have an IQ level that's significantly below normal. It's not an insanity defense. They can't show that they don't know the difference between right or wrong, but their intellectual capacity, it's undisputed that it's significantly impaired. And in that situation, the Supreme Court in the United States has said the death penalty is not appropriate. Yincher, are you with us? Can we?
I'm here.
Okay, do you want to ask your question? You might want to get closer to the mic.
Oh, can you hear me?
Just barely.
Oh.
I know it's early where you are, and you probably are trying to be quiet.
Can you hear me now?
Yes.
Okay. My question is, Maruta mentioned victim's feeling is one of the three considerations of when giving death penalty. But I'm just wondering what a defendant could do to relieve the victim's feeling. For example, can the defendant do something to get a forgiveness from a written forgiveness from the victim? So in this case, even though there's a victim participation, but somehow because the victim already forgave the defendant, so this penalty is not likely to be imposed. But I don't know, Maruta, I asked the question earlier, and Maruta said compensation is not really an indicator in Japan. But I'm just wondering what else can defendant do to receive this, to show his remorse and to receive the victim's forgiveness.
Oh, that's very interesting question. Chi, I think thank you for your question. And first, I would like to mention more about why Japan introduced victim participation. That is for the serious murder cases, and they can attend, not only the murder cases, but also the robbery and arson and other serious felony cases. In the Taiwan trial, they allowed to attend the victims. That is designed to include some private civil compensation claim. That is, simultaneously they can ask the kind of compensation for the lost victim or injured victim at the end of Taiwan trial. This is decided by professional judges because Taiwan has no jurisdiction, no power to decide that. So usually the victims come with defense lawyer, their lawyers, and the lawyers, after the criminal sentencing, deciding, they also file the civil compensation to the three judges tribunal, and three judge tribunal will give some judgment on that. So it is not before the trial. It is a simultaneous, things. So when the criminal verdict comes in, then after that, the civil compensation is, decided. So that's the very interesting system, but still totally different from Chinese one. And as I said, in the different from the felony cases, more, say, example, the misdemeanor cases, hit someone, injured someone, or steal someone's property. Court is very much weight and put the weight on whether they privately compensated, or they privately settled each other on the loss or damages, and the prosecutor will sometimes, or more often. I have now a very interesting injury case. I mean, the guy, hit and broke the nose of the victim. I myself is now, paying some money to get the lenient sentence, or even suspension of the indictment. So that's the system before the trial. But even in, I mean, it is limited only to the felony, I mean, not felony cases, misdemeanor cases. If you pay $1 million before the murder, I mean, compensation to the murder case victim's family, it doesn't work, I think.
So,
Go ahead.
well, I was going to turn to another question,
Sure.
but so we have an interesting question from Richard Hertzfelder about sort of the relationship between prosecutors and the Taiwanese system. Can we turn on Richard's microphone and ask him to ask his question? So I see, Richard, you're still muted.
Mute. Can you hear
Great.
me?
Yes.
Yes.
Okay. Second unmute worked. Yeah, my question was, I saw the slide where you laid out the number of death penalty requests by the prosecutors. And I was wondering if prosecutors are asking for the death penalty less often since the lay juror system went into effect. I noticed that the top line, for instance, is in single death cases, the slide showed 100 requests in 29 years, and that's 3.5 a year. But since then, it's been only 8 cases in 9 years. And I didn't have time to notice what the ratios were with the other type of case, but I just wondered if prosecutors are asking for the death penalty less often, either because of the lay juror system itself or because of for other reasons.
Well, I mean, so maybe your question is how and why a prosecutor decide death sentence, even in the first. I mean, the victim is one. Sometimes they do not ask death penalty, but sometimes ask the death penalty. That's your question.
Yeah, sometimes they do, and sometimes they don't. But they seem to be asking less often in recent years.
Well, I would say prosecutors has sentencing data, and the joke. I mean, as a joke, we say that if prosecutors ask 10 years, the judges automatically reduce 2 years. I mean, so 80% is the market price. So it is kind of automatical because judges really rely on prosecutors' argument and documents and the presentation. They just write their judgment based on the prosecutors, the materials, not rather emotional defense lawyers one. So prosecutors has a very good record all over the nation. They have what kind of case prosecutors, I mean the past record, they had that one. And so they can tell in this case how much we ask court to sentence, or whether it is life imprisonment or death penalty, really based on not discretion. They have based on the data. So data shows what kind of weapon was used, how much they were injured, and what they feeling. So as I said in Nagayama Criteria, that kind of criteria they have much more precise. And then they based on that, then they request the court death penalty or not life imprisonment, not death penalty, life imprisonment, or 30 years old, because it really based on the past record. So, I mean, prosecutors, it's not recently, they don't ask death penalty. No, it's not that one. They just in time anyway, before Taiwan and after Taiwan, they just based on the case nature, case features to analyze which sentence must be the, best request. They just do that. And usually I said 80% is the market, real marketplace. But death penalty is whether death penalty or not death penalty, life imprisonment. It really depends on the judge to decide. Not 80% death penalty. So I think prosecutors in Taiwan era, they less requested one person's murder case. No, the number of the murder case is not so many as compared with the American case, I mean the US case. So from 1980 to 2009, they had 29 years, almost 30 years, the data and the professional judges. And I compared that one with only 20 years of, but still it's small number. It is not because of Taiwan system. They just based on their own past record. They decide requested sentence. That's my answer.
Okay, interesting. We had a similar question about whether, again, about is there a perception that lay jurors are either more lenient or more likely to impose the death penalty than professional judges. Since we don't know, the vote is not public, we don't have the data, but I'm just in the Japanese defense bar or among judges and prosecutors, is there a perception about lay judges' leniency as compared to professional judges?
Yes, that's another interesting question. Judges, professional judges, I'm not sure how much they are influential or they persuade lay citizens. But actually, in the Japanese society, it's kind of vertical relation society. The lay people respect professional judges, and they will explain how they decide the sentencing. And by explanation, by telling them, teaching them how to decide, maybe implicitly or consciously or unconsciously, they read what is the ideal sentence or what is the most expected sentence. That happened, I guess, there must be that kind of influence. So if the jury, they person decide the sentence by themselves among 6 people, it will be different. But judges always pay attention to follow a past sentencing inclination or data or trends. So because if it far from other, the other usual cases, the higher court will overturn that kind of sentencing, and it's not good for the professional judges. They discuss the sentencing with the lay persons, but it's not honorable. It's not desirable for their promotion or other things. So they are more careful about paying attention of the past sentencing records, and intentionally or unintentionally they lead to the Taiwan for that way. But still, Taiwan has a voice, and they emphasize emotional aspect. Taiwan, the professional judges will be influenced by that, I think.
So procedurally, when the court issues a sentence, do they write a decision or an opinion explaining why they imposed the sentence that they did? Would they cite the Nagayama factors, or did they just say, we impose a sentence of capital punishment, or we impose a sentence of life imprisonment? Do they give their reasons?
Yes, they will give. They will just issue some court judgment statement, and both fact finding and also the reason of sentencing. And the reason of the sentence is very much interesting because it's a combination of the lay citizen's opinion and judge's opinions. So sometimes it revealed what kind of argument was going on. And then some cases, they say the victim's feeling must be considered very seriously, that kind of thing is inserted. That means we can tell. Judge never say that. So maybe, I mean, the judges insisted that aspect. Yes, to answer your question, we have written document, a written statement of the Taiwan trial court. So through that, we can guess or some we can get some hint what kind of argument was going on.
Professor Maruta, one of the big issues in the United States is the intersection of plea bargaining and the death penalty. And in states where there is the death penalty or in the federal system, there's always a question, would a plea bargain be entered into to spare the defendant the death penalty? In other words, the prosecutor agrees to recommend a life sentence in exchange for a guilty plea. I know Japan has a limited formal guilty plea process, but whether it's under that process or otherwise, do Japanese prosecutors ever agree not to seek the death penalty if the defendant agrees not to contest the charges against him? Is that something that happens in practice?
As a bargain, well, you're asking the relation with the plea bargaining and death sentence.
Yes.
Yeah, and we have, well, I mean, I just should say that the plea bargaining, Japan has two aspects. One is official plea bargaining. We have only 3 cases after 3 years. I mean, they started official one. It is designed to pick up organized crime and also serious business crime, not murder case or not other cases other than criminal, I mean, the business and gangster organized crime cases. So that's one aspect. We have only 3 cases, but unofficial plea bargaining we have actually in Japan. So what I said is, other than murder case, we usually, negotiate with prosecutor by showing we are settled between the victim by paying money, and victim signed of the receiving some cash money, and also we ask those people to sign to the letter to ask prosecutors very lenient or very to drop the case, that kind of thing. So
right, but that's in non-capital cases. That's just in
exactly,
minor cases.
Yes.
Professor Maruta, I apologize, but we are running out of time, and we still have a couple of questions in the queue, but and I apologize to those who didn't get a chance to ask their questions directly, or because of time, we didn't get a chance to cover those topics. I would encourage you to write to us at the US Asia Law Institute or write to Professor Maruta directly to continue the discussion. But we often say that a sign of a good program is one where people don't want it to end. And I think we've met that standard. You've given us a provocative presentation, an informative presentation, and you could see from the questions that you generated that it's a topic of great interest. And we really had a great discussion. So I appreciate all the questions.
Thank you.
Appreciate your answers. And as Professor Upham said, thank you for staying up late and spending this hour and a half with us. And for closing out, I think a very successful speaker series here at the US Asia Law Institute for the fall semester. So I wish you good night.
Yes,
And
thank you.
to those of us in time zone where we're just starting our day. Wish everyone a good day and thank you for participating. Hope to see you soon
Yeah,
on
thank
Zoom
you very much.
or even better in person.
Sure, thank you. Have a happy new year. Bye-bye.
Bye-bye.
Good night. Good night.